In this episode, we review 3 probable cause hearings held before Judge David Fletcher in the Harris County Criminal Court in Houston, Texas. A probable cause hearing occurs shortly after an arrest, especially a warrantless one. Under Article 15.17 of the Texas Code of Criminal Procedure, the arrested person must quickly be brought before a judge, who advises them of their rights and reviews law enforcement facts to determine whether probable cause existed. If not, the defendant must be released. Our first hearing was on November 4th, 2024, after Raquel Rodriguez was charged with DWI on October 28th, 2024.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank two beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the DIMS, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1-leg stand. He also noticed that I think she took off her boots for the 1-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that the stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat.
Judge Fletcher found no probable cause because there wasn't enough evidence of intoxication to justify standard field sobriety tests, or SFSTs. Since SFSTs extend the traffic stop, officers must first have reasonable suspicion of an intoxication offense. In this case, the only evidence was the odor of alcohol and Ms. Rodriguez stating she had 2 drinks, the last one 2 hours earlier. Judge Fletcher ruled this was insufficient to extend the stop under state and federal law, including Article 38.23 of the Texas Code of Criminal Procedure. Any evidence obtained through an unlawful stop cannot be used in court, so the SFST results were excluded. With no probable cause, the arrest was invalid, and the charge was dismissed on February 24, 2025. The next probable cause hearing on November 4, 2024 involved Keon Shaw, who was charged on October 28, 2024 with fleeing a police officer under Texas Transportation Code 545.421 for willfully refusing to stop when signaled by police.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
terms.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man, good luck.
Judge Fletcher found no probable cause because there was no specific allegation of how fast the driver was going, meaning the initial traffic stop lacked a lawful basis. Even though the Transportation Code doesn't require a lawful stop to charge fleeing, the Constitution still applies. Under Article 38.23 of the Texas Code of Criminal Procedure, any evidence from an unlawful stop, including the officer's claim that the driver didn't stop, cannot be used in court. The Fourth Amendment requires reasonable suspicion supported by specific, articulable facts. In Ford v. State, 2005, Texas courts ruled that vague statements like following too closely without details do not establish reasonable suspicion. Similarly, Judge Fletcher determined there were insufficient specific facts here, so the arrest lacked probable cause. The state dismissed the case the same day. The final hearing occurred January 27, 2025. Defendant Francisco Cerda was charged with engaging in organized criminal activity under Penal Code 71.02, which applies when 3 or more individuals collaborate in committing crimes such as drug dealing, robbery, or, as in Cerda's case, theft.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wanted to talk about
Is that C or an S?
the judge.
Okay. Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
Judge, my concern, if you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged act.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your
what
Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time. So-
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, we could just maybe reset it for a week or so, we call the witness. And we have to
No, he's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay, all right, for sure.
Judge Fletcher found no probable cause because the only allegation against Mr. Cerda was being present in the stolen U-Haul. As the Amarillo Court of Appeals explained in Munoz v. State 2000, proving organized criminal activity requires showing that the defendant intended to participate in a group carrying out multiple crimes over time. Simply being present for one incident does not meet this standard. Here, there was no evidence that Mr. Cerda was involved in more than one criminal episode, or that the three defendants had an ongoing agreement to act together. Therefore, Judge Fletcher ruled there was no probable cause, and the state dismissed the charge on February 24, 2025. These hearings illustrate why probable cause determinations are vital. Arrests without warrants deprive individuals of liberty, and judges like Fletcher, who scrutinize the evidence rather than rubber stamp arrests, protect constitutional rights and strengthen public confidence in the justice system. Let us know in the comments if there's a courtroom case you want covered. Thanks for watching, and don't forget to subscribe and share to help foster a more informed society.